On the 14th of January of 2022, the Court of Appeal Criminal Division handed down judgment in the Crown and James Hugh Brown, which is now reported at 2022 1 Criminal Appeal Reports 18. The case was concerned with whether a prosecution at common law, where a statutory offence could have been charged, will constitute an abuse of the process of the court and lead to a stay of the proceedings. The facts were that James Brown was a member of a group of climate activists styling themselves the New Pretenders and linked to Extinction Rebellion. He was substantially visually impaired and was a well-known Paralympian and a successful businessman. On the 10th of October of 2019, at least 10 members of the group, including James Brown, launched what the Court of Appeal later described as a concerted attack on London City Airport. Brown purchased a ticket for the lunchtime British Airways flight to Amsterdam and then continued through the airport as an ordinary passenger and, because of his disability, was invited to board the aircraft before the other passengers. Other members of the group glued themselves to departure gates and tried to disrupt the Docklands Light Railway. And all these activities were carefully coordinated using WhatsApp and were deliberately designed to cause maximum disruption to the operation of the airport and maximum inconvenience to the travelling public. When James Brown arrived at the door of the aircraft, he clambered onto the roof and then superglued one of his hands to the fuselage. All of this was being filmed and live streamed both by him and by his fellow protesters within the terminal building. Eventually, a cherry picker was fetched and a debonding agent was used to dissolve the glue and remove him. But the disruption was substantial. The aircraft in question had to be taken out of service for the day, leading to the cancellation of its 4 scheduled flights, affecting 359 passengers, with the people concerned missing birthday celebrations, other family events, and business meetings. The adjacent taxiway had to be closed, and 6 other flights were delayed. James Brown did not dispute his actions, but he said that he needed to do something spectacular in order to grab the attention of the media and to publicise how air travel increases global warming. At his trial in the Southwark Crown Court on a charge of causing a public nuisance, it was submitted on his behalf that the case should be stayed as an abuse of the process of the court, since the allegations could have been charged either under London City Airport bylaws or as an aggravated trespass under Section 68 of the Criminal Justice and Public Order Act of 1994. The latter carries a maximum sentence of 3 months' imprisonment. The trial judge, His Honour Judge Perrins, refused that application. The defendant was convicted of public nuisance and he was sentenced to 12 months' imprisonment. On his application for leave to appeal against conviction and sentence, the Lord Chief Justice Lord Burnett referred, amongst other cases, to the Crown and Rimington 2006 1 Appeal Cases 459 and then held as follows. Firstly, an application to stay an indictment will be granted either where a defendant cannot have a fair trial or where it's necessary to protect the integrity of the criminal justice system. Secondly, charging a statutory offence rather than a common law offence is a matter of good practice, but failing to follow best practice does not of itself threaten the integrity of the criminal justice system. Thirdly, the trial judge had expressly concluded that the prosecution was compatible with Articles 10 and 11 of the European Convention on Human Rights, and in particular that it had a legitimate aim that was proportionate and was necessary in a democratic society. The abuse jurisdiction is a creature of domestic law and it doesn't turn on any issue under the Convention, so all that was required here was an application of the principles in Rimington. Fourthly, there had been good reason to charge the common law offence, where the gravamen of the offending was serious disruption of the public's right to use London City Airport. And in the circumstances, the court granted leave to appeal on that ground, but then dismissed the appeal against conviction. As for sentence, the offending here passed the custody threshold, and the right to peaceful protest did not mean having to tolerate behaviour which was far removed from simply conveying a strongly held conviction, and instead aiming to cause chaos and as much harm as possible to members of the public. However, given the impact of prison on this man because of his substantial impairment, the sentence of 12 months imprisonment was reduced to one of 4 months, and that meant that he'd already served the custodial part of his sentence and he was released with immediate effect.